Well, now it's the turn of the speakers to my right. Let's start with Peter Jago. Peter Jago started his career as a lawyer with Sinclair, Roach and Temperley, and now he is a partner of Moore, Fisher and Brown in London. He will speak about how to choose an arbitrator, which is a quite interesting question. So we're all waiting for the right answer. Thank you.
Thank you and good morning. We've heard this morning about some problems and cases that have arisen as a result of shipbuilding and shipbuilding contracts. My particular focus is on problems that can arise during the construction of vessels, and I'm assuming that the builder still wants to build the vessel and the buyer still wants to buy the vessel, but they have a disagreement of a technical nature. How is this best dealt with? Well, I appreciate that if I stand here as a lawyer and say we are the best people to deal with it, there could be a mixed reaction amongst the delegates. I suspect those who have tried London arbitration probably have mixed views of that, and one view might be slow and expensive, but fair enough maybe. So what do parties do? Well, shipbuilding contracts that I've come across often, they can have a myriad of different formulae, but sometimes there's provisions to refer to the High Court, sometimes to arbitration, and often to LMAA terms, and sometimes to a technical man. Now, the High Court can be speedy, can be efficient. An issue there is it's public, and the parties may not want this technical matter raised in public. The builder, well, it can damage the reputation of the yard if something is going wrong. The buyer, well, if the buyer has to take the ship, it can damage the reputation of the ship, and he might want to resell it in due course, and the world will know it had certain issues during its construction. So High Court may be not the most appropriate. Arbitration, well, London arbitration is the one I'm familiar with, and I've confessed to the view that it can be slow and expensive, so not always the favourite, and this can drive the parties to include provisions to refer technical problems to a technical man. The type of references I have seen are to refer technical issues during construction to the Classification Society, or to a surveyor or technical man appointed by the chairman of a classification society, or simply that the parties will agree on a technical man when the issue arises. Now, I've seen this work. I've seen this arise in a number of cases, sometimes very well, quick, speedy, and the right solution which the parties could live with, at least, and maybe even were happy with. But I've seen disasters. I've seen muddles, confusion, and a complete waste of time. And of course, in my scenario, the ship is being built, but if building grinds to a halt because a decision has to be made whether to progress in that direction or that direction, then time is of the essence. So I thought I'd just run through very quickly some English principles that apply if you appoint a technical man. Now, if in the contract you set out the procedure he must follow, then he will have to follow those procedures. He can't deviate, he must do whatever is set out. But quite often in the shipbuilding contract, when it was created, you haven't included a procedure that must be followed by the technical man, so that's often absent. But if there is a procedure and the technical man deviates, then you can go off to court and challenge what he's doing. But that brings us back to the first problem. Now we're in court, and that's what we were trying to avoid. So to avoid going to court, often the shipbuilding contract will provide that the technical man's decision is final and binding. And it is important, probably, to exclude the right of going to court if you're going to have a mechanism for speedy resolution of these problems. Final and binding, just note, it may not be enough to prevent applications to court. You may have to add final, binding, and expressly say no appeals to court, no applications to court, for that to work. But if you are going to clothe the technical man with such power that his decision will be final and binding, then it's just worth bearing in mind what you're going to get. And some of the problems that can arise are illustrated in a case, Bernard Schult and Nile Holdings, a 2004 case that ended up in the High Court. It's not actually a shipbuilding dispute case. It was a sale of a fleet. And for reasons of confidentiality, the buyers were not allowed very much access to the vessels they were buying until after they had agreed to buy. The contract then provided that there would be an adjustment on price depending upon the findings of a technical man, a surveyor, who would look at the vessels and the market values, and there would be a final adjustment. And this proceeded, and the case illustrates just about everything that can go wrong. Firstly, the reference to the technical man provided that he would be appointed by the chairman of Bureau Veritas. But he had to be appointed within a certain number of days. Well, the application was made to the chairman of Bureau Veritas within time, but for whatever reason, the chairman didn't make the appointment in time for some of the vessels. And the question then was, were those vessels time-barred? And the answer the High Court gave was yes. The rules required the chairman of BV, who had no contractual obligation, he wasn't a party to any of this, he probably didn't know of this term. The court said, well, he could have been on holiday, but this is what you've agreed. If he doesn't appoint in time, those claims are time-barred. So that knocked out quite a few of the claims. But the ones that survived, well, the parties were unhappy with, particularly the buyers, because they made representations to the technical man about the value of the vessels, and it's fairly apparent that he just didn't even read them, didn't hear them, didn't look at them, completely ignored them, went off on, I would say a tangent, but he went off on his own, formed his own view about the values, and made an award, made a decision. And so the buyer said, well, what about fairness? What about natural justice? We've referred to the technical man, but we expected him at least to hear our submissions. And the court said, too bad. He doesn't have to hear your submissions. This is what you get with the technical man. And I'll just read a very short section from the judgment where the judge, Mr. Justice Cook, contrasted the procedure before a technical man and before judicial arbitrators such as Mr. Harris. He said, a person sitting in a judicial capacity decides matters on the basis of submissions and evidence put before him, whereas the expert, subject to the express provisions of his remit, is entitled to carry out his own investigations, form his own opinion, and come to his own conclusion regardless of any submissions or evidence adduced by the parties themselves. So actually the only constraints on the technical man are decision fraudulently or with collusion or bias. Well, you know, as long as he's honest, whatever he does, it will carry. And I had I was involved in a similar, a similar problem. It was the construction of a chemical tanker. And I was acting for the yard on this occasion, and the supplier of the weld material to the yard managed to mix up certain types of batches. The chemical tanker had stainless steel tanks, and the end result was that in each of the tanks there was some of the correct weld material and some incorrect. And our argument for the yard was that it didn't matter. The buyer took a different view. He thought it mattered in two respects. One was he may not be able to carry all the cargoes he was intending, and the other was that the life of the tanks and therefore of the vessel may be curtailed, may be shortened by this. So a technical man was appointed to decide. He was asked, please make a decision. Does the weld material, the wrong weld material, have to be removed from the tanks? There were lots of implications to this because the ship could never have been delivered on time if the answer was yes. But he was asked to answer this, yes, no. And after about 3 weeks of mulling around, his answer was yes and no. He went off somewhere, and we don't know where, but he went off somewhere and formed the view that the weld material in the bottom sections of the tank would be under greater stress, and that had to be removed, but not the wrong weld material in the top parts of the tanks. Now, neither party had argued that. It was actually incorrect in the view of both the yard and the buyer. Nobody was interested in that, but that was his view, yes and no. It satisfied nobody. But I'm pleased to say there was a happy ending. We then set up a very speedy arbitration. I mean, the parties knew their case by now. We'd been arguing about it for ages. So within 7 days, a tribunal in London of 3 arbitrators was formed. The parties submitted their cases. We had a one-day hearing and a decision. And so over and done with. So I'm not here to play off technical man against us lawyers, but I am here to say just beware of what you might be getting with a technical man. On small specific disputes, you will get a quick, speedy decision, hopefully, and that can bring it all to an end very, very well. But just beware that he will act without constraints, and he's free to act without constraints unless they are imposed. But if you impose constraints, then you may end up in court anyway. I'm not saying lawyers are best, but just bear us in mind. Thank you very much.